Yet your February 15, 2007 update, that's the first time that you provided that information to the State Bar regarding that case. Isn't that true?
Well, I do believe I referred to that information in a telephone call with yourself prior to that date.
Did you provide it in writing to anyone at the State Bar prior to that date?
I don't believe so.
And in fact, the State Bar filed a response in this matter in December of 2006, correct?
I don't understand.
Are you aware that the State Bar filed a response in this matter in
Which
December
matter?
of 2006, this moral character proceeding?
Yes.
Did you receive a copy of that?
Yes, I did.
And in that response, the State Bar actually lists this case as well as the two others that you failed to put in your application and update, correct?
That's correct.
And you didn't actually provide an update of this until after the State Bar filed its response, correct?
Well, prior to that, I had referred to them on the phone to you and told you that I would be needing to provide that in writing.
You know, I want to look at something. In this Exhibit 3, page 1, you state, please accept this correspondence as an update for my moral character application filed September 28, 2002. I have previously indicated to Ms. Kagan that there were several matters to which I need to update my previously filed moral character application. What did you mean by that statement?
Just that. I told you there were things that I needed to update.
So you were aware that there were things that needed to be updated in your application that you had yet to do?
I was aware there was a possibility, yeah. I needed to go over it with a fine-tooth comb. And
Okay, let's go to...
since I didn't even realize the unlawful detainers fit within that, I didn't realize they were judgments. I don't recall ever,
Is that why you didn't update your application until February 2007 regarding those cases?
Regarding the unlawful detainers?
Yes.
I knew I had been evicted, but I didn't know legally what that meant in terms of there had been, I guess, a judgment for an unlawful detainer, and that amounted to something that fit within this application. So for those two matters, that was more a case of me not knowing quite what those amounted to.
Did you ever ask anybody what those amounted to?
No, I don't believe so.
Okay, and as you're referring to both of them, let's just go back to, or go to Exhibit 63. That is the case of River Arms Apartments v. Zachary B. Coughlin, Washoe County case number REV 2006-00909, related to an unlawful detainer for default in payment for rent at 1255 Jones Street, 132, Reno, Nevada, in the amount of $720?
Yes.
And
I still don't understand how there can be two separate ones for. I don't think you get to stay 2 months for, without paying. So I don't. There's one residence. How can there be two unlawful detainer actions? I don't understand that.
As of today's date, have you made any payments toward the $720?
Other than the damage deposit was kept in its entirety, which was, I believe, $300 or $400.
But my question is, did you ever make payment toward the $720?
Well, I believe that damage deposit would be applied towards that. So other than that, no, but that would amount to a payment, I believe.
Do you know that for certain?
No.
Okay. Now, my question was, if you look at page 1, there's a total of $720. Have you ever made payment? And that is, if you look at it, due date of rent $595, total late charge applicable $50, due date of 3/1/06 for $75. It's a total of $720, correct?
And that's what I don't understand is it's like these are two separate actions, but they're both dated from March 1st. You know?
Do you see the difference that one actually takes place in 2005, which is Exhibit 62, and one takes place in 2006, which is Exhibit 63?
Well, my photocopy's not so clear I can't read that. And, well, now here I see 05.
As of today, have you ever made any payment towards the
I don't know that that's
$720?
I don't know why they can go back and say you didn't pay a year ago.
Mr. Coughlin, please answer the question. The question is, as of today's date, have you made any payment towards this $720?
I'm not sure. I'm not sure if the damage deposit is applied towards that or not. Other than that, no, I haven't.
Now, there was another court case, which is represented in Exhibit 60, and that is Shipping Services DBA Unishippers v. Zachary Coughlin individually, DBA Coughlin Memory Foam. Washoe County case number RSC 2005-00301. Correct?
Correct.
And that's a small claims case against you for non-payment of shipping services?
Correct.
And there was a judgment for plaintiff in the amount of $5,161?
Correct. Well, I think it might have been for $5,000, and the amount over $5,000, I believe, is some sort of cost. So I understand that small claims actions are limited to $5,000.
Have you made any payment towards that $5,161, Mr. Coughlin?
I'm not sure.
Do you have any evidence with you of payment that you made on that?
No.
Now, you knew about that case as of March 18, 2005. Isn't that correct?
I'm not sure. Is that the date the case went to trial?
No, actually, that's the date that you filed a letter with Judge Schroeder in that matter, which is Exhibit 60, page 22. Dated March 11, 2005. Dear Judge Schroeder, I'm writing to request an opportunity to defend my case, though I was not present on the date specified in the order, RSC 2005-000301. So would it be fair to say that as of March 11, 2005, you were aware that this matter was ongoing? You were aware that there was a case filed against you in this matter?
I think that would be fair to say, yes.
Yeah, you didn't update your application to include this until February 17, 2007.
What does the application say? Something filed against you, or does it say a judgment rendered
Let's
against you?
read it. Okay, so Exhibit 1, which we went over earlier, page 11, states, civil actions and administrative proceedings. Have you ever been a party to, or are you presently a party to any civil action or administrative proceeding? You checked no, correct? Mm-hmm. And you didn't update that section until February 2007, correct?
Well, as I mentioned before, I had referred to it on the phone with you.
Was that, strike that. Do you have any documentation to that effect?
I don't believe so. No.
Okay. And so why didn't you update, if you knew about it since March of 2005, why did it take you approximately 2 years to update your application to include that information?
I'm not sure. I think at some point I wasn't. I didn't remember exactly what needed to be reported within this application. I was more sure of things like, if you got arrested, you need to report that. But this is something a bit more tenuous and a bit further into the fine print of the application, in my opinion. Also, at some point, I seem to remember thinking there might have been something in there about this, and then I wasn't sure whether I had received a final adjudication in that matter, and whether or not that meant I could still appeal it and therefore not fit within what's called for by the application. However, as I read 11.2, it says, have you ever been a party to? So I think that would mean whether or not I had won any appeal, that was something that would have been needed to be reported. And I don't think, as of the date of this application, it says you need to report it within X amount of time. I think that was a subsequent thing that was added to applications where maybe the rule went on to say 30 days you need to report something by. But regardless, at some point I should have been aware of that and I should have reported it. And while I did refer on the telephone to you and say that there's some things I need to report, that was still pretty late in the game and pretty far out from when it should have been reported.
In fact, you didn't report this until after the State Bar filed its response setting forth this case, correct?
Right. Which was surprising to me because you had said you'd give me an opportunity to update my application and refer to the things we discussed on the phone. And then at some point, I guess you decided you had to get something filed. So I wasn't maybe either given quite the opportunity, or if I was, I didn't take advantage of it quickly enough.
Do you have any documentations of these telephone conversations you had with me, Mr. Coughlin?
Other than phone records showing that we talked on the phone several times, I don't believe so.
Okay, I'd like to turn to Exhibit 1. Back to the section regarding bondedness, discharge of obligation, indebtedness on page 13. And I'd like to discuss something other than the student loans. Under 13.5, do you owe any debts, including student loans, that are past due? And you checked no, correct?
Yes.
Oh, actually, let me finish it. Include those barred by the statute of limitations and past due credit account balances. You see that part of it? You checked no, correct?
That's correct.
Okay, in February of 2007, as part of Exhibit 3, you provided a list of debts that are past due, correct?
Yes, I did.
Okay, and that's on starts with page 5 and goes through page 8, correct?
Yes.
Okay, so let's look at the first one, Argonne Agency for $470 past due of as of October 2006.
Yes.
Okay, so February of 2007 is the first time you notified the bar of that debt, correct?
I believe so, yes.
Why didn't you notify them back in October 2006?
I'm not sure. I should have.
Would it be fair to say that, let's see, the next one, AFNI, $148 past due as October 2006, correct?
If that's the sort of thing called for, yes, I should have.
And you didn't provide an update until February 2007?
As far as I remember, yes.
Collection Service of Nevada Digestive Health Center, $133 past due as of December 2006, correct?
That's correct.
And the only update or the first update you provided is February 2007?
Right.
River Arms Apartments, $1,532.
That's what, a month and a half later or something?
River Arms Apartments, $1,532, past due as of November 2006. Correct?
Well, I don't know that I fully agree with that debt. As I discussed earlier, I don't understand how there could be 2 months' worth of unlawful detainer. You know?
But you do understand that there are 2 judgments against you for that amount, correct?
Yeah, I guess so.
And then Macy's, $55 past due as of October 2005.
Mm-hmm.
And February 2007 is the first time you updated your application regarding that?
I believe so.
Last one, Wells Fargo Bank, $836 past due as of November 2005.
Yep, that's correct.
And February 2007 is the first time you updated your application to include that?
I believe so.
Are all of these debts still outstanding, Mr. Coughlin?
I don't know what written off means, if that means it's no longer outstanding. But if it doesn't, then yes, I believe most, if not all of these are still outstanding. However, I think the charter communication debts might have been taken care of.
Okay, on this exhibit at page 5, under section 13.5, past due debts, you write, I incurred debts in addition to the unlawful detainer actions mentioned in section 11.2. Steps taken to address the debt. I have tried to get my law licenses in California and Nevada so that I can repay these debts and to work my program of recovery towards the same goal. Was that a correct statement at the time that you made that?
Yeah, I believe so.
You've been licensed in Nevada since March 2005, correct?
That's correct.
You can practice as an attorney in Nevada?
Yes.
And after leaving Hale Lane in December of 2005, have you had any legal employment in the state of Nevada?
I've done a few research projects for Tom Hall, I believe.
Anything else?
I don't believe so.
Is there anything preventing you from working as a lawyer in the state of Nevada?
Well, getting hired is, that's one thing. It's been difficult to find work. And for a time there, I had gastritis, so that made it difficult. And then there's this proceeding, which I don't know if you haven't gone through something like this in a first-person type way, I don't know if you can really appreciate the extent to which it kind of involves your life. And I think it's illustrative to look at when I got gastritis. I was working full-time in a litigation setting and heavily involved with dealing with the lab program and working with them. And so I think I look back at that, and in considering this hearing coming up, while I've tried to find work, I've also realized that this hearing is something that is takes something out of somebody.
What litigation firm are you talking about?
Hale Lane.
Correct me if I'm wrong, but weren't you let go from Hale Lane and you were advised that it was not a good fit?
I'd object to that on the basis that I signed a severance agreement with Hale Lane, and it seems to have some language in it that indicates that I'm either not allowed to or be subject to some sort of penalty for discussing my employment with Hale Lane.
Okay, but the question is just were you let go? I think she's not asking for details. So I'm going to...
Yeah, as far as I understand, I was let go, as far as I understood it.
And you testified at your deposition that you were let go and you were told it was not a good fit,
That's correct.
Okay. You never mentioned anything about gastritis at the time that I asked you at the deposition about that job, did you?
I am not sure. But I was beginning to suffer from gastritis at that time, I know, but I didn't get treated by Dr. Hinojosa until following the termination of that.
Dr. who?
Hinojosa.
Okay, let's move on to your employment with the law firm of...
And I would just point out that perhaps this is a situation where, you could say, well, the lab program's designed to do a lot of good, and it probably does do a lot of good, but in some instances...
I'm going to object to this on the basis
There's
that no question posed.
So you can explain it as it relates to a question.
Okay, I'd like you to turn to Exhibit 2, page 3. It's a letter, February 23, 2003, to Kathy Curry from Zach Coughlin. And...
That's Exhibit 2?
Exhibit 2, page 3.
Okay.
Okay, in this letter, you write, also, I have been let go from my position at Schuring, Zimmerman, and Scully in light of my recent arrest, and hope this letter complies with my duty to keep the bar informed as to my employment history. Correct?
I'd object because this letter isn't signed.
Is this a letter that you wrote?
I'm talking about
I'm not
page 3
positive.
of Exhibit 2.
Oh, I'm sorry. Okay, page 3. Your question is, did I write this?
Well, yes. Did you write this?
Yes, I believe so.
Were the statements contained that I just read true?
I'm not sure because I don't know exactly what Sharon Zimmerman's motivation was for letting me go.
But you wrote that in a letter to the bar, correct?
I wrote what?
I have been let go from my position at Schuring, Zimmerman, and Scully in light of my recent arrest, and hope that this letter complies with my duty to keep the bar informed as to my employment history.
I don't know that that means that that's the rationale Sharon Zimmerman gave me for letting me go.
But that's what you informed the bar, correct?
No. That depends on how you read that sentence.
Well, how do you read it, Mr. Coughlin?
Also, I've been let go from my position at Sharon Zimmerman and Scully in light of my recent arrest and hope this letter complies with my duty to keep the bar informed as to my employment history. And that would go back to your earlier statement about me not having him informed.
Right, I struck that question.
Okay. How would I read that? It doesn't say Sharon Zimmerman told me that was why.
Okay, let's move on to
In
exhibit...
fact, that wasn't, I don't believe why they told me.
Oh, that wasn't why?
I don't think so.
Why were you terminated from
I
that
think they
position?
told me it was because they needed me to have a Nevada license. And the abeyance order that had been issued December 18th, 02, which I didn't get until after moving there and starting work. I think was why they said, well, we need you to have a Nevada license.
So they didn't let you go in light of your recent arrest?
You'd have to ask them that. Objection, hearsay.
In your opinion, what was the reason for them letting you go? Was it because you couldn't get your Nevada license?
My opinion is that I'm not sure why they let me go.
Exhibit 15.
And even if they told me why they let me go, I still wouldn't be sure why they let me go.
But you didn't put that in your letter to the State Bar. I'm not sure why they let me go. You wrote, in light of my recent arrest, correct?
I'm not going to say that.
I'm asking for what you wrote in your letter.
You're asking me to agree with what your impression of what I wrote meant. That's different than asking me what I wrote.
Mr. Coughlin, I asked you whether or not you informed the bar about the Nevada licensing at that time, or whether you wrote, in light of my recent arrest.
I'm sorry, I don't understand your question. You lost me on...
Let's move on. Okay, Exhibit 60, Exhibit 15, page 63, is a letter dated February 23, 2003, to the State Bar of Nevada. So this is the same date as your update to the State Bar of California, only this is to the State Bar of Nevada. And in this letter, you write, also, I've been let go from my position at Schuring, Zimmerman, and Scully. I was told I was let go because they need someone who is licensed in Nevada, and that the Supreme Court's deferment order was too far out for them to keep me employed. Correct?
I believe so. What exhibit was that again?
That's Exhibit 15, page 63.
Page 63. That's what's written on that page.
Is this your letter to the Nevada State Bar, Mr. Coughlin?
I believe so.
I request that Exhibit 15, just page 63, be moved into evidence, Your Honor.
Okay, let's see. Exhibit 15, page 63 is admitted into evidence.
So on the same
I
date...
object on basis of relevance, Your Honor.
It's overruled.
So on the same date that you wrote the State Bar that you were let go from that firm in light of your recent arrest, you wrote to the Nevada State Bar stating that you were let go because they needed someone who was licensed in Nevada, correct?
Those are the words that are in either of those letters.
All right, let's move on to back to Exhibit 1, page 13, regarding scholastic discipline. Scholastic discipline. Under this section, have you been dropped, suspended, expelled, or otherwise disciplined by any school for any reason other than academic performance? And you checked yes. If yes, state the reasons fully below, providing the name of the school, the date, and the reasons for discipline and the final disposition. And you write, I was fined $100 by UNLV for moving a computer monitor and keyboard 10 feet to attach my computer for an hour in December 1st, 2002, University of Nevada, Las Vegas, correct?
Correct.
Actually, the conduct took place on October 11, 2001, correct?
Can you tell me where you were reading that from? No, it's from the original application.
That was from your California application, yes.
Okay. Okay, so yes, I did write that, and you're saying the incident took place on October?
October 11, 2001?
I don't know. I'm not sure.
Okay, let's look at Exhibit 58, page 5. And this is a letter or a memorandum to Dr. Rebecca Mills from Christine Smith, dated October 22nd, 2001. It's CC'd Zachary Coughlin. Do you recognize this letter?
Yes.
Okay. While we're on this exhibit, do you also recognize page 7 of the exhibit, which is a copy of a check in the amount of $100 to Board of Regents, UNLV, from Zachary Coughlin?
Yep. Yes, I do.
Is that the $100 that you paid for the computer incident?
Yes, it is.
Okay. I move to have Exhibit 58, pages 5 and 7 into evidence.
Is there any objection?
No, Your Honor.
Okay.
So
And
it would be, let me just get
Sorry.
this, Exhibit 58,
yes,
pages
5 and 7.
58. Let me write that. Or admit it.
Okay. So it states in this page 5 of the exhibit, on the evening of October 11, 2001, Zachary Coughlin disconnected the computer monitor, keyboard, and mouse, which are set up in the microforms room of the UNLV Law Library. See attached memorandum of Matthew Wright. This machine is not for general student use. We have 2 computer labs with over 30 computer stations, as well as Carol's with network connections. Mr. Coughlin chose not to use these facilities and decided to dismantle without authorization an entire computer station dedicated to the purpose of reviewing microforms in the microforms room. And it goes on to say, strike that. So is that a fair statement of what occurred on October 11, 2001 regarding the computer?
I would say it's not a real complete statement, no.
Was the computer for general student use?
I think it was for students to use. What you mean by general, I'm not sure. If you mean,
Was it attached just for use to the microforms?
I'm not sure.
Did you have authorization to disconnect that computer?
I'm not sure.
Why did you use that computer, Mr. Coughlin?
It's kind of a somewhat complicated reason. As I remember it, my home computer wasn't able to get on the internet because the internet service provider software that needed to be used, I believe it was Prodigy at that point, had become corrupted or in some way was no longer functional. And so when I called the tech support, they told me that I needed to get another copy of that Prodigy program reinstalled so I could start using the internet to get it home. And I couldn't, the only place I had to go get a copy where I could get on the internet was at school, but I couldn't get a copy of that program because it was too large to save to a a floppy disk, and we didn't have CD burners back then, or these USB drive. We didn't have those available to us back then. So what I had to do was I had to take my home computer to school and try to download it, the Prodigy program, onto my computer at school. I tried to do that in the rooms that they're speaking of, these computer labs, but for some reason I wasn't able to get it to work there. And so after trying that, then I tried this other computer that was outside the computer lab. And, you know, for about 10 minutes, I needed a monitor to use with the computer I brought from home to get on the internet and download this program so I could fix my computer and use it at home. And I did that, and then and that's what happened.
Did you have authorization to use that computer for that purpose?
I don't believe so, no.
Did you ask anyone whether or not you could use it for that purpose?
I don't think so. This was like 6 o'clock or so, I think, like on a Friday, though. So.
Okay, let's move on. Exhibit 2, page 2. Now, let's go through this again. Is this your letter to the State Bar of California?
Exhibit 2, page 2.
Yes.
I think it is. If it was signed, it would be easier to be sure about it.
What about the fact that your letterhead is at the top of the letter?
Well, I don't know that, you know, means it's definitely mine. If that were the case, anybody who put my letterhead at the top of the letter could write any letter they wanted and say it was mine.
Okay, let's talk about March 19, 2003. On that date, did you live at 1044 West 1st Street, Reno, Nevada, 89503?
I think so.
And the first page of that exhibit, it's entitled Amendment to Application. And it states, I, and you filled in your name, Zach Coughlin, understand that my application, whether filed as a registrant or as an applicant for admission to the practice of law in California, is a continuing application. For this reason, I amend my application with the following additional facts and information which correctly and fully bring the previously filed application and amendments to that application to a current status. This amendment applies to items blank of my application as follows. And you write, please see enclosed letter. Is this the letter you're referring to, the same date as the title page, 3/19/03?
I would think it is.
Okay. In this letter, you write to the State Bar stating, I have not been referred to any treatment. Oh, wait, let me just find the exact. Okay. It's the 4th paragraph down, approximately 2 sentences from the bottom. I have not been referred to any treatment programs for drug or alcohol abuse, nor am I currently enrolled in treatment. Was that a true statement at the time that you made that?
I believe it was, but it depends on what you're defining as treatment.
What about treatment programs?
If you're saying going to an AA meeting is treatment, then.
So you wouldn't consider. I'm sorry. So you wouldn't consider AA to be a treatment program for drug or alcohol abuse?
It would depend who was saying treatment and how they were using it.
In fact, Mr. Coughlin, as part of your conviction in March 2003, you were sentenced to attend 8 AA meetings by June 10, 2003, correct?
That's correct.
And that's represented by Exhibit 67. Page 5. Superior Court of California, County of Sacramento minute order header proceeding, case number 03T00937, correct?
Correct.
Okay, on March 11, 2003, you pled nolo contendere to a violation of Vehicle Code Section 23103, drive reckless, non-alcohol related, correct?
That's correct.
Okay. And so as of March 11, 2003, you were ordered by a court to attend Alcoholics Anonymous meetings, correct?
Yeah, I guess so.
Yet in your March 19, 2003 update to the California State Bar, you didn't include that information, did you?
Objection, relevance.
Overruled.
I didn't include what? That I had.
That you were sentenced to attend 8 Alcoholics Anonymous meetings by the court.
I don't see that in the letter.
Okay, I want.
Is there something calling for that in the letter, or is that?
Well, that's actually a good question. I'd like you to turn to Exhibit 20. Do you have Exhibit 20 in front of you?
Yes.
Okay. Exhibit 20 is a letter to Zachary B. Coughlin from Kathy Crary, dated March 5, 2003. And in the letter, it states, please provide the following. A copy of the police report from the arresting agency regarding your January 2003 arrest for DUI. Please describe your relationship with alcohol and or drugs. This should include when you started drinking or using drugs, at what age and where, and outline your current drinking habits and or drug usage. This statement should list any referrals or rehabilitative programs in which you have been enrolled for treatment of abuse issues. Keep in mind that the rules regulating admission to the practice of the bar and practice law in California provides an applicant has a continuing duty to update response to questions in all applications whenever there is an addition or change to the information previously furnished. Okay? Did you receive this letter?
Yes.
And is your March 19, 2003 letter to Ms. Crary a response to this letter?
The one that had the police report that says that I had to go to AA meetings? That one?
No. I'm talking about the March 19, 2003 letter.
That
It's
the police
Exhibit
report
2,
was
page
included
2.
with?
I'm sorry?
That wasn't the police report included with that letter?
Yes, it was.
So wouldn't that obviate the need to tell you that I was sentenced to these if it's included in
Well,
the letter?
actually, let's see exactly what was included.
To the extent that fits within a referral, which I'm not sure that is a referral to a treatment program as spelled forth here.
Actually,
Which you have been enrolled for treatment of. See, I don't know
l-
that
I-
AA meetings
let me go
amount
back a minute.
to enrolled in a program.
did you understand what she was asking you to provide, Mr. Coughlin?
Who?
Ms. Crary, in her letter? That's Exhibit 20.
She wanted a copy of the police report?
Yes, and what else?
She wanted me to describe my relationship with alcohol or drugs.
Okay, and?
And to list any referrals or rehabilitative programs in which you have been enrolled for treatment.
So, did you understand what she was asking for?
I'm not sure.
And in response to that letter, you submitted this letter dated March 19, 2003, correct?
I think so, yes.
Okay, and I'd like to just go through the letter.
In addition to this police report that lists these AA meetings that it says I need to attend. So to go back to
But
your
you didn't
earlier
put that in
question,
your letter, did you?
if this police report is attached to my letter, then as a total, yes, I would say in whole it's in my letter.
Mr. Coughlin, my question was, is that language included in your letter
What
of
language?
March 19, 2003 to Ms. Crary
What language?
regarding the AA, attendance at AA?
In the police report that I sent her?
No, Mr. Coughlin, my question is your letter.
But I view my letter as what's in.
I'm talking about this
included
one-page
in
letter.
the envelope.
Is it in this one-page letter? That's Exhibit 2, page 2.
Objection. Relevance.
Well, here's what I would say. You're allowed to explain. You answer yes or no and explain it.
Okay. Your question is what?
Is it in the letter?
Is
The
the AA
reference
meetings,
to AA meetings, yes.
the court's ordering me to go to some?
Yes, is that referenced in the letter?
I don't believe that's referenced in the letter.
Okay.
The letter, though, just to be sure, is
You can explain your reason as to why it's not referenced.
it's if it's not referenced in the letter, and I don't believe it is, but I don't have the letter immediately in front of me.
Isn't it page 2 of
Exhibit 2.
2?
Page 2 of Exhibit 2.
That's the letter.
Okay. I have included my arrest report in this letter. So I'm referencing this arrest report, which includes this court's sentencing me to that. Whether or not it goes on further in the letter to spell that out, I don't see that.
Okay.
A certified copy of the minute order is included, indicating the final disposition of my charge. Included in that disposition is this AA meeting language. So, I don't know. I think that's an open interpretation whether or not I've included that in this letter.
And Mr. Coughlin, isn't it true that you told the committee at the informal conference of July 8, 2004, that you were a sober member of Alcoholics Anonymous since January 1st, 2002?
I think those are words that I used.
Yet that's not in this update of March 19, 2003, is it?
No.
There's no reference to AA in this whole letter, is there?
Well, other than where it's referencing the minute order and what's included in that minute order. No, I don't believe so.
Okay. I'd like to look at some sentences in the
But
letter.
I would say that goes to highlight what I consider to be a rather rudimentary understanding of alcoholism and AA on your part. And that would be that it seems that you feel that the minute someone goes to an AA meeting, they become a member of AA, and from there on, they're required to identify themselves as such. And as there's
Mr.
really
Coughlin,
no
I'm
room for
asking you-
looking into it or exploratory type of investigation. It's once you've done that, you're.
Mr. Coughlin, I'm asking you about statements you made at the informal conference on July 8, 2004. On that date, you made the statement, I have been a sober member of Alcoholics Anonymous since January 1st, 2002, correct?
I believe so.
Yet, you don't include that language in this letter, did you? This language, this letter that is Exhibit 2, page 2.
Well, you can start going to AA and not feel
Mr.
you
Coughlin,
really
just answer the
belong
question,
there.
please.
Okay, you can start going and not really be on board with it. You can just be going to see what you think about it, you know, and then after the fact you can say, well, okay, I've been going, I wasn't drinking, so yeah, I guess I didn't really know it at the time, you know.
Mr.
But now that I
Coughlin,
look back on it, yeah, that was the germination of my recovery, or that's where things started to change, or I started to look at things differently. But I don't think anybody in the history of recovery has just one day been like, oh, this is me, that's it, boom, I'm in recovery. You know, it's a process. It's not a...
Mr. Coughlin, did you make that statement at the informal conference?
Which statement?
That you've been a sober member of Alcoholics Anonymous since January 1st,
Yeah,
2002?
I think I did.
Okay, and going back to Exhibit 20, please describe your relationship with alcohol and or drugs. This should include when you started drinking and using drugs, at what age and where, and outline your current drinking habits and or drinking usage. This statement should list any referrals or rehabilitative programs in which you have been enrolled or for treatment of abuse issues. Okay, so that is March 2003, correct?
Mm-hmm.
And yet, nowhere in Exhibit 2 do you mention that you have been attending Alcoholics Anonymous meetings, do you?
Exhibit 2 is...
Page 2.
And that is what I sent Ms. Curry?
Yes.
Well, actually, if I'm giving you this in the police report that says I have to attend the meetings, then I guess that would mean that, yes, I had been telling you I'd been attending meetings.
Okay, and where in the police
Isn't it?
report does it say that you've been a sober member of Alcoholics Anonymous since January 1st, 2002?
Objection, relevance.
Overruled.
I don't know that it does say that in the
Where in the
police
police report does it say that you have attended Alcoholics Anonymous meetings in the past?
report. Where it says part of the condition for this dry reckless is to go to these meetings.
I'm talking about in the past, before you were ordered to go.
I don't know why a police report would talk about that.
Okay,
I don't know why you'd ask me that question, as if there's a duty to say, if you've ever gone to an AA meeting, there's a duty to say you've gone to an AA meeting? Is that what you're saying? Because if that's what's being said here, the precedence, then let's really say that so that nobody ever goes to an AA meeting again. Let's just get that out of the way. Because if they do go to an AA meeting, then they need to report it to you, right, Susan? And then where do we go with it? You know.
Okay, what's the next question?
Next question is, same exhibit, Exhibit 2, page 2, second sentence. While I would like to point out that I was not under the influence of any drug when I was pulled over for having my seatbelt unfastened, I must admit that I had smoked marijuana in the weeks preceding my arrest. Is that a true statement?
I believe so.
Are you aware that the toxicology report found that you tested positive for THC?
I believe so, yeah.
And yet, when you were asked that same question regarding...
Positive for use within, within a 45-day window? Or are you saying there's any sort of specificity to when it said I used it, or are you just saying in general?
I asked you whether or not you were aware that the toxicology report tested positive for THC.
Right. Yeah, I'm aware that the report, as I understand it, indicates that the person testing positive has been exposed to THC within somewhere around 45 days within testing positive.
Okay, what about the statement 3 paragraphs down, first sentence? I started drinking alcohol in my early 20s and have never been more than a social drinker. Was that a true statement at the time that you made it?
I believed it to be true. But it's also the kind of statement where I don't think it's a true or false statement. It's a completely subjective statement. And it's like telling someone you love them. Do you know, true or false, that you love this person? Is it kind of a shade of gray? Is it something you're just kind of a gut feeling? You know? So if you're asking me, is that true or not, I'm telling you that that's not, that seems to highlight your rudimentary understanding of recovery again.
So let's talk about your DUI arrest. You were arrested on January 23rd, 2003 in Sacramento, California, correct?
You're referring to my conviction for dry reckless driving?
I'm talking about your arrest for DUI on January 23rd, 2003.
Okay. The one that was a dry reckless?
You were arrested for a DUI, isn't that true, Mr. Coughlin?
I think so. I think so.
Okay. And Exhibit 69 is the arrest report. Now, were you under the influence of any drugs or alcohol at the time you were arrested, Mr. Coughlin?
I don't believe so, but I should ask you, is ibuprofen a drug?
Were you under the influence of any alcohol or illegal drugs at the time that you were arrested on January 23rd, 2003?
No, I don't believe so.
Did the police officer...
I should... when you're saying under the influence of any drugs, does that include a prescription? And what do you...
The question was illegal drugs.
Okay. So we're not talking about prescriptions.
No, we're talking about alcohol or illegal drugs.
Okay. No.
Were you able to perform any of the field sobriety tests administered by the police officer at the time of your arrest?
It's my opinion that I performed them all quite well.
Isn't it in fact true that you failed every single sobriety test?
In fact, true. I don't know what you mean by that.
Mr. Coughlin, what's your basis for believing that you performed them all?
That I was there and I was stone cold sober and I saw myself perform them.
And in your opinion, you passed the field sobriety tests?
Yes.
Okay. But the officer had the opinion that you failed the field sobriety tests, correct?
I can't speak for the officer.
Were you unsteady on your feet?
Say,
Were you unsteady on your feet at the time of your arrest?
I don't believe so.
Did you have bloodshot, watery eyes at the time of your arrest?
Objection, relevance.
Overruled.
I don't believe so.
Did you have a strong odor of marijuana emanating from your car or your person or your breath?
I don't believe so.
And this, in your letter of 2002, Exhibit 2, page 2, March 19, 2003, you state, I must admit that I had smoked marijuana in the weeks preceding my arrest. I often wore the same sweater I was wearing the night I was arrested. I would wear it almost nightly to avoid turning on the heat in my apartment. The officer must have smelled marijuana on that sweater for nights when I had previously smoked marijuana. I would smoke marijuana sparingly on nights after work when my chronic mid-thoracic and cervical pain would be unusually bad. This would help me ease the pain, sleep and ease the pain. I've since started a chiropractic and physical therapy regime that also includes yoga. I feel remarkably better. Were those statements true at the time that you made them?
I believe so, yes.
Have you smoked pot since January of 2003?
I don't think so.
Have you ever kept pot in your residence since January of 2003?
I don't think so.
Have you ever kept anything that you used to smoke pot at your residence since January of 2003?
Objection, relevance, and...
Okay, what's the relevancy of...
Your Honor, I believe I have evidence of possible